Well, Pradeep, it's really nice to see you again. I wanted to catch up after our last discussion about the ongoing change in the Indian tax environment. And so you had mentioned last time the concept of faceless tax audits. So I know we're now through the first round of those. What has the experience been like?
Sure. Thanks, Rodney, for having me. It's always a pleasure to converse with you. See, the Indian tax authorities have been moving steadily in terms of conducting tax audits through the process of data mining and have been trying to integrate various sources of data. Just to give you an example, they made taxpayers corroborate data points in the income tax filings with filings from a GST or a customs law perspective. So that's the way the tax authorities are looking at in terms of mining data across spectrums. The faceless assessment regime is a critical milestone in convergence of conducting tax audits with the extensive aid of technology and data. So I think the focus of the tax authorities has been to sort of conduct tax audits through data mining. The faceless tax regime was launched in August 2020, and some of the key objectives were to reduce the direct interface with tax authorities with the end goal of eliminating corruption and ensuring greater transparencies, and also coming up with well-reasoned orders. From an experience standpoint, I would probably say that the first two cycles of faceless assessments have been a mixed bag. There has been an increased volume of information sought. The assessments itself have been a mere accumulation of various issues across various years, more of a old wine in a new bottle, rather than focusing on critical issues. Also, the intent of the tax authorities has been to sort of complete the tax audits within a short time frame without providing adequate opportunities. So what has this resulted in? It's resulted in several inconsistencies and irregularities on the manner in which tax audits have been sort of concluded. And taxpayers have knocked the courts with a slew of writs given the irregularities associated with completion of tax audits. So in order to overcome this, the government has also brought in legislative amendments in the recent budget to give more teeth to the tax officers in case of procedural irregularities. I think, given the state of faceless assessments, I think it's important for the government to sort of introspect on this a little closely and make the process more equitable to the taxpayers. They should probably focus on critical issues rather than factual matters or procedural matters. And also they should look at commencing the whole assessment in a timely manner so that, adequate opportunities are provided to the taxpayers and also ensure consistencies in terms of tax positions. So I think probably that is the summary of the experience on the faceless assessment regime, Rodney. I think it's a good start, but there's a long way to go.
Interesting. And how have India's general anti-avoidance rules played into that process? If you can just perhaps refresh me on what those rules actually deal with, and then perhaps the approach that you're seeing the authorities take.
Right. So, Ronnie, in the era we are living in, I think transactions cannot be disassociated from the lens of GAAR. Right. While countries such as Canada or UK have got established precedents on invocation of GAAR, from an Indian perspective, I would probably say 2017 was a watershed moment because the GAAR provisions got codified in the law. From a legislation standpoint, a GAAR has been specifically defined. It is defined to mean an arrangement, the main purpose of which is to obtain a tax benefit. So it doesn't talk about ancillary purposes or incidental purposes. It talks about it needing to be a main purpose. Okay. The typical scenarios where GAAR can be sort of triggered is where transactions sort of are not done at arm's length or where it lacks commercial substance or bona fidity. And interestingly, the provisions of also got a particular clause to say that if there is a step in the arrangement which is intended to obtain a tax benefit, even though the whole arrangement is not intended to obtain a tax benefit, GAAR can still be triggered. Okay, so that's a very interesting kind of a provision which is there in the Indian legislation. So what are the consequences? I think the consequences are fairly draconian. It can range from denial of tax treaty benefits to recharacterization of income or expense, or even lifting of the corporate wheel. So there are fairly stringent rigors that get triggered if GAAR is sort of invoked. From an Indian perspective, therefore, one needs to strike a fine balance between tax mitigation so that it does not lead to tax avoidance. And I think this is an area which the tax authorities will increasingly look at focusing on. So what are the typical issues in the GAAR context? I think probably a debt push-down kind of a structure, or a cash repatriation, or royalty payouts to IP holding companies, or even restructuring will all be susceptible to GAAR, at least from a tax authority standpoint. And therefore, it needs to be sort of threaded very, very carefully. In fact, there have been at least 2 instances where GAAR red flags have been raised by the income tax authorities. And this was before the company law authorities, interestingly. So this was a case where, not the taxpayer, but the applicant was looking at, undertaking a restructuring. And the tax authorities objected to that scheme by saying that this was intended to avoid taxes. So you are seeing GAAR being used as a tool by the Indian tax authorities, and definitely this will be a tool which the tax authorities are going to latch on to in the near future. Given the same, I think the manner in which the Indian courts would like to deal with the GAAR provisions and their interpretations in the years to come would be an interesting space to watch out for.
That's really interesting. And talking about looking into the future, tell me a little bit about your views on how the multilateral instrument and perhaps BEPS Pillar 1 and 2 are impacting or are likely to impact multinationals in India.
So I think MLI is at least reasonably mature from an Indian perspective. It's been on for the last couple of years. Pillar 1, Pillar 2, we'll just need to see how they are enshrined into the Indian law. But my take on the MLI is that most of the treaties which India has got has enshrined the MLI provisions in some form or fashion. So, for example, the principal purpose test is there in most treaties. And therefore, one would need to ensure that the requirements therein are duly complied with if they're looking at latching on to any treaty-related benefits, for example, on capital gains or on dividend withholding, etc. There have also been other articles in the MLI which has been brought into the Indian treaties. A classic case is the dividend transfer provisions, Article 8 of MLI, which is there in the India-Slovenia treaty. And therefore, I think one good sign is that India is slowly trying to sort of move towards the more accepted international tax principles, and they're trying to sort of have that thing enshrined either in the treaty or the domestic law, which potentially is a welcome move. But obviously, taxpayers will need to navigate through this in an appropriate manner. Otherwise, they risk the situation of tax treaty benefits getting denied, right? So from a Pillar 1, Pillar 2 perspective, I think, India has also got a particular provision, which is on equalization levy, right? Which is akin to what is sort of be covered in Pillar 1. The only difference is that this is not based on profit allocation, but probably a percentage of the turnover that is generated by foreign companies in India. And therefore, the manner in which the Pillar 1 provisions are going to get enshrined into the Indian income tax laws remains to be seen. I think India has made a commitment to abide by what the OECD is going to come up with from a Pillar 1 perspective. But whether this will mean that provisions such as equalization levy will go off, what's going to happen to withholding taxes on payouts such as royalties or fee for technical services, etc. So those kind of things remains to be seen. But hopefully the government will come up with something which is more harmonious. And again, the government will also need to factor the loss of revenue, because Pillar 1 proposals, only apply to the big tier kind of, or the large tier companies, and their impact may not be as much in terms of what the government is able to collect through the equalization levy. So I think a fine balance needs to be struck on that. From a Pillar 2 perspective, I think clearly it's going to have a significant impact on Indian companies, especially if India seeks to adopt both the income inclusion rule and the under-tax payment rule. So, for example, IIR would have a bearing on Indian MNCs having overseas presence, especially if these overseas jurisdictions are structured through low-tax jurisdictions, which has been, typical routes which Indian companies have sort of adopted. And UTPR is going to kick in on intra-group payments, while most of the payouts are more than the 9% rate. But I would still feel that there could be certain payments which will fall within the ambit of UTPR, which needs sort of analysis. From an issue standpoint, some of the aspects that the government will need to sort of also consider while coming up with the whole roadmap on Pillar 2 proposals would be, how does, let's say, UTPR play with transfer pricing? Because you already have a transfer pricing provision under the Indian domestic laws, which seeks to disallow certain kinds of payments which are not at arm's length. So how does that play with UTPR? The government probably will need to pay a closer attention to it. Similarly, from an IIR perspective, how does that interplay with POEM? So today there is a scenario where if Indian companies manage companies outside India and its place of effective management is basically in India, then India reserves a right to tax the profits earned by the foreign company under the POEM rule. So how is that going to play with IIR would be another interesting area to watch out for. And lastly, when does potentially your IIR get triggered? Let's say you have a tax holiday which has been enjoyed by the overseas entity, or if they're entitled to certain concessions or exemptions on account of their whole regimes, for the classic case being IP regimes in Ireland or trading regimes in Singapore, etc. How will those income streams become taxable in India is another area to sort of consider. So I think the right approach, in my view, Rodney, would be similar to what UK has adopted, where you go through the public consultation mode, where all these issues are put up, and hopefully, recommendations are sought from taxpayers, from the general public, etc., before this gets implemented, because there are a whole host of issues which are there from a practical perspective as well, which requires consideration. But I think this is certainly a space that's going to create a lot of excitement for professionals like us, as well as taxpayers. Because they would need to sort of ensure the right structures, so that they don't fall foul of these provisions.
Which is fascinating, Pradeep. So clearly just a lot going on. Sounds like great progress on the faceless audits in terms of using technology. A nice reminder about the general anti-avoidance provisions and just keeping those in mind. And then that ongoing progression towards international norms, particularly in the area of MLI and BEPS. Just a lot to look out for in the next short term, I'm guessing, Pradeep. So that was a fascinating analysis. Thank you very much for your time today, Pradeep. It's good.
Thanks, Rodney. Always a pleasure talking. Thank you.